Welcome to the Savant webinar on blending legacies, estate planning for yours, mine, and ours. My name is Tim Bender. I'm one of the presenters today, and I'm a wealth transfer advisor with Savant. And you'll see a bio on the screen now showing a little bit of my background. But I was an estate planning attorney in private practice for about 30 years prior to joining the financial services industry, going in-house. In this role with Savant as a wealth transfer advisor, I'm a member of a bigger team that supports our financial advisors, meets with clients, provides information, guides to clients on all things related to their estate planning. And that often involves written analysis. It's often one-on-one meetings with the clients. And this role is really a lot of fun for me. I'm very pleased in today's webinar to be joined by Theresa Harezlak. And I'm going to let Theresa introduce herself, but she's one of our outstanding financial advisors here at Savant.
Well, thanks so much, Tim. I'm excited to get into this topic today. I've been here since 2007, and I've been able to help them go through a lot of different transitions in their life. And none of them are the same. They all are unique. And it's just wonderful to work with such an incredible team of people. As I said, I've been at Savant since 2007. But I've been in this business since since 1988. I do hold a designated certified financial planning designation. I also hold a designation that helps people going through a divorce to find an equitable and reasonable settlement. And I'm in the process of getting my certified estate planning designation, which mixes the legal part of estate planning along with the financial and practical part. So this is a topic that is near and dear to me, and I'm excited to get going.
Thank you, Theresa. So the agenda for today, we want to talk about some fundamentals of estate planning, then focus on estate planning for a single person, talk about estate and financial planning for a couple contemplating marriage, then talk more specifically about estate planning after marriage, especially with blended families. And as time permits, we certainly like to be able to take a few questions. So to go ahead and jump right in, fundamental elements of estate planning. So I would say, first of all, that every adult has an estate plan, but not everyone engages in estate planning. And I think as we go through the next few slides, you'll see what we mean by that. So every adult, if they don't do their proactive estate planning, has a default estate plan that applies during life or at death. And during lifetime, the default estate plan, if you do not do your own estate planning, would be if you become incapacitated. So now you're not able to pay your own bills, manage your own financial affairs. Somebody can petition the court to have a guardianship appointed over your property. And that somebody who petitions the court may not be who you want petitioning the court, and whoever is appointed as guardian may not be who you would have chosen. And that party petitioning the court to have this guardianship established might even be a creditor of yours who's concerned about not being paid, so they're petitioning the court to get a guardianship to make sure that they're paid. If you're unable to take care of your own physical person, there might also be a guardianship over the person established. So again, that's a court process. Somebody institutes it. It can be expensive. It's a matter of public record. Parties may be appointed as a guardian that you wouldn't have chosen. During lifetime, without a healthcare appointment document, a healthcare power of attorney, if you become incapacitated and cannot make your own healthcare decisions, then state laws kick in to allow somebody to be recognized or to be appointed as your healthcare power of attorney or a healthcare representative. And that hierarchy differs from state to state. Most states will say, well, first choice would be a spouse, maybe adult children, adult sibling, but not all states are like that. So for example, I know in Colorado, the law there says any of the following people could be appointed as your healthcare representative if you have not appointed someone in your documents. And so that could include a spouse, a child, a friend, advisor. There's no priority under that default provision under Colorado state law, for example. So that's the default estate plan during lifetime. At death, the default estate plan, if you have not done your own estate planning and now you die, no will, no estate planning, now your assets at death are going to pass in accordance with the laws of intestate succession. And those are laws that each state has that basically writes a will for you by that state. And it's that state assuming, well, where would this person have wanted property to go if they had had a will? And so typically that's going to be the nearest family members that you can think of. So a spouse, children, parents, aunts, uncles. But the priority amongst those people and the percentages that each of those people might receive can differ from state to state. And again, this is a court process. Somebody's petitioning the court to get an intestate estate opened. Somebody's petitioning the court to be appointed as the executor of that intestate estate. And now there's a determination, a process to try to figure out what does state law say who your heirs are and who in fact are those people, who are your heirs, come forward. With this default estate plan too, there may be a lot of income taxes or estate taxes that will be due, that will be incurred, that could have been avoided or could have been minimized if you had done your own proactive planning. So some examples of famous people or celebrities who have died without estate planning. And each time a famous person dies and they have not done their own estate planning, I can tell you when I was an attorney in private practice, business went up right then because they saw all the bad things that happened. But a few examples: Howard Hughes, Sonny Bono, Prince, and all these people I would say were not that old. So Howard Hughes was 70, I think, when he died. Sonny Bono was 62. Prince was 57. But Howard Hughes might be the most interesting or involved one. So Howard Hughes died in 1976. Again, he was 70 years old at that time. And as you know, Howard Hughes was a notorious recluse, very, very secretive. And at the time that he died, it appeared he did not have a will, so he died intestate. So again, his assets, his estate, which even in 1976 dollars, he was a billionaire, his estate was passing according to the laws of intestate succession. So an intestate estate was opened up, and now the games began. I've read that over 600 people petitioned the court saying that they were an heir of Howard Hughes. And out of those 600 people, probably not a surprise that it included a few women who said they were secretly the wife of Howard Hughes. Of course, he was a recluse, he was secretive, so there wouldn't be any documents to support that. And they couldn't produce any documents, so the court didn't accept that they were wives. There was also a lady who petitioned who said that she was Howard Hughes' mother. And Howard Hughes was 70 when he died. This lady who petitioned and said she was his mother was 64. Well, the court didn't buy that one either. There were also, I think, at least 3 states involved in these proceedings, all arguing that Howard Hughes died a resident of that particular state because the state of residency could increase the death taxes payable to that estate. So ultimately, the determination was that Howard Hughes' estate passed to a whole bunch of cousins. And I've read differing numbers between 12 and 20 cousins is where his estate passed. And this was involved in litigation for over 34 years. So that's one example of a default plan that maybe didn't go so well. Prince, a little more recent, died in 2016, I believe. Again, he was 57 years old. Appears no will. So his estate was opened as an intestate estate. And now less people came forward. I think it was maybe 40 people or so claiming to be intestate heirs, some alleging to be children. That all got sorted out, and it was determined that Prince's heirs were really 6 siblings. But this proceeding kept dragging out, and these siblings weren't really getting distributions from the estate yet, and they were incurring legal fees to be fighting off these other claims of people who were claiming to be heirs. So these siblings were running out of money to pay legal fees. So some of the siblings even had to sell their inheritance rights, their inheritance expectancy, to a third party in order to get cash. And then when the estate actually settled, it didn't go to those particular siblings. It went to the party that they had assigned their rights to. Sonny Bono, I think again, he was 62 when he died. Not maybe as complicated as the others, but Sonny, I believe, was on his 4th wife at the time of death. Had 4 children. Cher was wife number 2, and she was even filing claims in Sonny's estate related to unpaid alimony or unpaid property settlement. So those are some examples, again, of default plans. I really doubt that Howard Hughes would have wanted his estate to drag on for 34 years, go to all these cousins, and the unknown attorney's fees involved. So you can avoid all that. Do your own estate planning. And so we've been talking about estate planning and what is it? So this is just my own definition, but estate planning is planning proactively through your possible incapacity during life and arranging for the orderly and tax-efficient transfer of assets during life or at death in a way that accomplishes your desires. That estate planning, very often we would like to do it once, think that it's done for the next 30 years. But really, estate planning is fluid. It's something you should review from time to time. So maybe every 5 years or so, take a look at your estate plan, see if things seem to pass, see that you're naming people in the way that you want to. Even earlier than that, if there's a material tax law change, and there probably will be, because there are all kinds of tax legislation that happen from time to time that can affect your estate planning. Or if you have some significant life event, and what is that? Well, it could be marriage, it could be moving to a different state, it could be a child getting married. So all of these things, at least every 5 years or so, review your estate plan, do your own proactive estate planning, and keep on top of things. Avoid those default provisions. So to shift from the fundamentals and now talk about estate planning for a single person. So for a single person, do your own proactive estate planning, avoid that default possible guardianship during lifetime. And one way of avoiding that possible guardianship is by having a financial power of attorney or power of attorney over property. And very often people think, oh, that's just a form of document. I can pull something off the internet. It'll work just fine. And I would really discourage that because there's a lot that can go into this. So first of all, who you name as an attorney, in fact, it needs to be somebody you trust. They don't have to be a financial expert. They can seek advice, but somebody you trust. Name your first choice. If you have a second choice, name that. Third choice, name that. But because, again, you're trying to avoid a possible guardianship over property by having a financial power of attorney naming who you would want to step in. And to pay attention to the powers that are being granted. Typically, you want to grant broad powers to this person as your attorney, in fact, your agent, because you're wanting to make sure they can do the things that are needed to take care of you without having to go to court. And those powers may differ from state to state. And you can certainly exclude some powers if you wanted to. But again, typically, you're trying to make sure and grant broad powers. So look at who you're naming as an agent, what are the powers, and then also what's the effective date of this power of attorney. And two general ways of drafting that. One is for the power of attorney to be effective immediately when it's signed. Another way is to state that the power of attorney is effective only upon some event like incapacity. And then the document may define incapacity. And this is an actual document I read just the other day. It said that this power of attorney will become effective upon my incapacity, and my incapacity shall be evidenced or determined upon a written certification by 2 independent qualified physicians. And that all sounds kind of good. It seems to roll off the tongue and sound real nice. But in today's age, when you think about that power of attorney being presented to a third party, and you think about everybody being concerned about the opportunity for fraud, you go back to all those words, that kick in that power of attorney. So there needs to be a written certification. So certification, does that mean that in the document, the physician has to say, I certify? Or what if they just said, in my opinion? And then you say, I guarantee, I promise, I certify. One I just read as an example said it had to be 2 independent physicians. So independent, does that mean that that physician cannot be associated with a medical practice I've seen before, or can't be associated with the hospital I might be at? Or does it mean they must be on their own? Not just a physician, independent, also qualified in the example I gave. So what do they mean by a qualified physician for this purpose? Is that somebody who is experienced in geriatric care or the particular disease that I might have? So if you're going to have a power of attorney that springs upon incapacity, be aware there could be some hiccups, there could be some problems having that kick in. It might be that you want to make the power of attorney effective immediately, but maybe control distribution of the document. So maybe you don't give your named agents copies yet, but you let them know where they could obtain a copy if they needed to. So just some things to think about. Have an advance directive, a healthcare power of attorney. Name your first choice, your second choice again. Who can step in and make healthcare decisions on your behalf if you're incapacitated? Have a living will if you'd like to express your desires to say, I do or I don't want extraordinary life prolonging procedures used to keep me alive if I'm in a terminal condition. That's all part of estate planning during lifetime. Estate planning, passing property. Think of different ways now that you can arrange to pass property. So certainly during lifetime, you could give property away. Now, there could be some gift or estate tax implications, and we'll talk about estate taxes a little bit more in the future, but certainly property can pass by gift. Another way of passing property at death would be by beneficiary designation. So pretty much any financial asset that you can think of, an IRA, life insurance, a bank account, a broker, after-tax brokerage account, you can pass by beneficiary designation. Some of those beneficiary designations, you might call it a pay on death or a transfer on death beneficiary or designation, but it's still who that account or that asset is paid to at death. And where you have beneficiary designations, that particular asset or account passes directly to the named person, no delay, no probate. Another way property can pass would be by title. So something titled or owned joint tenants with rights of survivorship, and that's distinguished from tenants in common. Joint tenants with rights of survivorship, by that titling, upon one co-owner's death, automatically passes to the other co-owner. Now, for a single person, a non-married person, it's generally not advisable to own things joint with rights of survivorship, because that other co-owner during your lifetime has access to those assets, could reach them, or a creditor of that other co-owner could actually reach those assets during your lifetime. So if all you're really intending to do is pass that asset to a person at death, not get them lifetime rights, you probably don't want things titled joint with rights of survivorship. Instead, having your name a beneficiary, have a financial power of attorney where you can name somebody to step in and access your assets, like this account in your name, but name a pay on death beneficiary. 529 plans, just a note on those are plans for higher education typically. There's always an account owner and a named beneficiary, but the account owner is the one who has the rights to pull money out of the plan or to name a successor account owner. So if you're a 529 plan account owner, name a successor account owner who can step in as the owner of that plan if something happens to you. We'll talk more about revocable living trusts later on in the presentation, but a revocable living trust, if that's established during lifetime, that will pass property that you title in the trust during lifetime, or property that you point to go into the trust at death. So by beneficiary designation, for example. In a revocable living trust, you'll typically include or can include protective provisions that say after death, here's how this property will be held and used and distributed. Another way of passing property at death now is a last will and testament. So a last will is kind of the way of last resort oftentimes. A last will only picks up something you own at the time of death that did not pass one of these other ways. Anything that passes by will requires that there be a court proceeding, a probate proceeding. But now in this last will, you can say that any property that passes by will goes where you want it to go, as compared to intestate succession, where it's dictated to go to your intestate heirs. In your will, you can leave the property where you want it to go. So have a last will, avoid intestate succession. And another important element of a will for people who have minor children is that is typically where you would express your desire of who would become the guardian of those minor children if something happened to you. Taxes. So even a single person has to worry about taxes, income taxes, estate taxes as a part of estate planning. A couple of laws that have come into play fairly recently that affect taxes on estate planning, and one is the Secure Act. And there's been a Secure Act 1 and Secure Act 2. But the first one was passed in 2019, and that made some changes as to how retirement plan assets must be withdrawn after the account owner is deceased. And now, as a general rule, anybody other than a surviving spouse, and there are a few exceptions to this, but anybody other than a surviving spouse who's named as a beneficiary of those retirement plan assets now must withdraw those assets within 10 years after the account owner's death. So obviously the government wants its money. It wants the IRAs to be pulled out, wants to have income tax paid on those IRAs. Estate taxes. Estate tax laws have changed tremendously over time, and the amount of the estate tax exemption has changed tremendously over time. And the estate tax exemption is an amount that can be passed to somebody other than a spouse or somebody other than charity before the federal estate tax kicks in. And I can remember when the estate tax exemption was as low as $600,000, But now the estate tax exemption in 2023 is almost $13 million per decedent. And that's where the exemption got bumped up to temporarily under a 2017 law. But it is scheduled to automatically sunset drop once we get to 2026 to where the law had been in 2013. And that's a $5 million exemption per decedent, but it's indexed for inflation. So it's estimated if we get to 2026 and the estate tax exemption higher amounts have not been extended, that the actual exemption will be around $6.5 to $7 million once you get to 2026. I mentioned for estate taxes, there are a couple of notable deductions. Once for what passes in a proper form to a surviving spouse. We'll talk about that in a little bit. Another's for amounts passing to charity. There's a complete estate tax deduction for amounts that pass to charity. Be aware, though, besides federal estate taxes, there are some states that impose their own state, and I'm going to call it a death tax. That might be an inheritance tax. It might be a state tax. And an example is Illinois. Illinois imposes a state estate tax, but the Illinois estate tax exemption is only $4 million per decedent, and it's not indexed for inflation. And it is not able, you're not able to pass any Illinois unused exemption onto a surviving spouse. So we'll talk about portability of the federal estate tax exemption a little bit, but just be aware the Illinois estate tax exemption is not portable. It cannot be passed on to a surviving spouse.
All right. So before we get into legal aspects of entering into marriage, we're going to look at just some of the practical financial aspects and things that you should really consider and things that you and your spouse or your partner should be very, very aware of. So first off, the most important thing when you're entering a marriage, and this is whether or not you're entering your first marriage or your second marriage or any type of union, when you are really combining finances, or at least you're combining your financial life. First and foremost, you want full disclosure, and you and your partner need to have a very, very good understanding of what your financial lives look like. Some of these things that you really need to talk about and you need to have the understanding is credit history. Your credit history will become a factor in the marriage's credit history. So you want to know what you're getting into, whether it's good or whether it's bad. You certainly want to know how it's going to impact you. The level of debt. What kind of debt do you have? Student loans, for example. You know, how much in student loans? What kind of debt may you have in terms of a judgment? You just want to go in with your eyes open and have a full understanding. Child support, things like student loans, income sources. What income sources do you have now? What income sources may you have in the future? And how will they affect this marriage? And then I think you really need a very, very clear understanding of what you are going to consider a marital asset and non-marital assets. And we're going to get into that in the next couple of slides here. Okay, so moving on to the next. We look at important discussions you should have and really why. So there's so much more to trying to blend a marriage, and there's so much more than just who's going to pay for what and how do things, you know, move in terms of our electric bill. So there's a few things you really, really want to have a good discussion about. First and foremost, expected inheritance. What's going to happen with an expected inheritance? I've seen a lot of couples where one person will receive an inheritance, and then that household, that family, considers that inheritance when they're looking at their spending. They're looking at their lifestyle. They're looking at what they're going to purchase. So when that happens, you have to think about this inheritance and how it's going to move through your life and move through your family. A short example, let's say that a couple inherits $1 million and they are living on that $1 million. They use that for their income. They use it to sustain their life. But the one person who inherited that million wants to leave it to their children. So now all of a sudden that person passes away, that $1 million passes to their children. And now you have a spouse who is very, very used to that life and who has bills to pay and has a lifestyle to pay that now does not have that $1 million inheritance anymore. So when you're looking at inheritance and you're looking at it to be a substantial part of your living expenses, you really need to talk about it with your advisor and talk about how the surviving spouse will manage and live without that inheritance. Charitable intentions. Do you feel the same way about that? There are a lot of ways to give to charity, but there are better ways than others. And, will you consider your charitable gifts separate? Will you consider them together? So those are things that you want to kind of get ironed out. Help supporting grown children. It's not uncommon for parents in this day and age to be helping their adult children. How do you feel about that? How will your new spouse feel about that? Same for college for children. Is this going to be something where you look at your income as a whole, as a unit, or will each parent be responsible for their children's college education, especially when you're in a second marriage? And then something that I don't think we talk about enough, but I think is extremely important, is how you're going to handle the care for aging parents. Most often than not, there are either the parent has sources and resources, or there are government programs put into place that can help with that. But even so much as just the emotional care, where are the parents going to live? Is it something where you're comfortable having the parents live with you? So there's all kinds of things that when these things are discussed, and I'm not saying you have to settle them. I'm not even saying you have to agree on them, but you just have to know that there are issues out there. And when you know that, the whole family dynamic just operates a little better. Moving on to the next slide. We've got a common way. There's really 3 common ways, and there's a million different ways that this can happen. But the 3 common ways that people either in a first, typically more in a second marriage, handle their expenses. So we call it the mine, yours, and ours buckets. Bucket 1, option 1, is really you keep everything separate. So each spouse enters with a certain amount of income, a certain amount of assets, and those are kept completely separate. You then figure out how you're going to pay the bills. Maybe you split the electric bill in half. You split the mortgage in half. You split vacations in half. I will tell you, this is a very, very difficult and cumbersome way to handle things, but it works for some people. So you really have to just kind of figure out what works for yourself. Clearly, communication and organization is critical. And this works best when you have like assets. Really doesn't work very well when one person has a significant more amount in assets than the other. I'm going to skip to option 3. And option 3 is, you combine everything. All income gets combined in a big pot. All assets get combined. All expenses get combined. And you really just kind of live your life and you consider it fair and even. A kind of a variation of this that we see is people keep their assets separate that they had before marriage, but any income coming through when the marriage takes place or after the marriage takes place, that then they kind of look at as joint. And then, then there's 2, and that's the option 2 is really a combination of 1 and 3. You don't keep everything separate, but you don't put everything together. And really, again, you just have to decide on what works for you. And what we see oftentimes is a couple may start with one option and then kind of move to the next option the longer they are together. The key, once again, is to communicate and be very mindful that you're both on the same page. Okay, can move to the next.
In contemplating marriage, something else to think about is, will we be residing in a community property state or in a common law state? So there are 9 community property states, and the rest of the states are common law states. And very generally, in a community property state, any asset acquired during marriage is considered community property and is actually considered owned right then, 1/2 by each spouse. So there's no court determination that happens that says we award ownership here or there. It happens by operation of law. But among these community property estates, there can be a lot of nuances on what is community property or not. So for example, if there's separate property coming into the marriage, that's not community property when it starts. But what about interest and dividends earned on that separate property? What about capital appreciation that's unrealized on that separate property, or actual capital gain transactions that convert that separate property into some other form? Is that still separate property, or is that income, that appreciation, capital gain, considered to be community property? So state by state, it can differ. And also property can be changed or transmuted from one character to the next. So something that was separate property by purpose or an accident could be commuted into different character property, community to separate or separate to community. And as you can imagine, after a period of years, it can be pretty tricky to determine what's separate property, what's community property. In common law states, again, which is all the rest of the states, so 41 states, they're equitable division states. So in a common law state, assets acquired during marriage aren't automatically considered legally owned one half by each spouse. So there might still be assets that appear to be titled in one name versus another name. But now when a divorce happens, now the court comes in and looks and identifies what's marital property and divides the ownership, establishes ownership at that marital property. So it didn't happen automatically during the marriage, it happened at divorce. Or at death, there can be a determination of property that should belong to the surviving spouse. So in the common law states, it's very common to have what's called an election to take against the will, or a right to take against the will in the surviving spouse. And basically what that is something built into law to make sure that one spouse can't say all the property is theirs, try to leave it somewhere other than the surviving spouse. The survivor has rights built in by state law to make an election against that will, against that estate plan, and get some of that property. Back to intestate succession. If there's not a will, there's not estate planning, and one of a couple dies of a married couple, typically that surviving spouse under all the states is an intestate heir, and usually is a primary intestate heir, gets a big share. Not necessarily everything, but it could be a big piece. And that's typically also true if it's a second or subsequent spouse, that can still apply.
All right, so things that are considered non-marital property. And I would put a big disclosure with this and say, whenever you are trying to blend families, the best thing you can do when you're trying to decide what is marital and what is non-marital is to seek legal and financial advice. But just going through the list, typically assets acquired before marriage, acquired by a gift, awarded by a judgment, acquired by a spouse after a legal separation, gained in exchange for a non-marital asset, sometimes the increase in the value of a non-marital asset, and things that are agreed upon. Maybe you have an agreement that one thing will not be considered a marital asset. A lot of times you hear the term prenuptial agreement. So this is where this could apply. Okay, we can move to the next. All right, so turning non-marital assets into marital assets. So in all the years that I've been doing this, I will tell you the most common thing that we talk about with clients when we're talking about leaving assets to kids and leaving assets to heirs, a lot of times parents want to make sure that their assets get passed to their children and then perhaps even to their grandchildren after that. So one of the biggest fears, of course, is you gift money or you give money to your kids, and then your kids end up in a divorce, and then it's a marital asset, and they end up splitting either their inheritance or their gift. So typically what's going to happen is when an inheritance comes to someone or a gift is made to someone, it is not considered a marital asset unless you make it a marital asset. And the biggest way people do this is they put those assets into joint accounts, or they do something like they buy a vacation home and they own that vacation home jointly with assets that they received from an inheritance or as a gift. So if you are mindful of not commingling those assets can be protected. Of course, if you do commingle those, then they become marital assets versus non-marital assets. A couple ways that you can protect that: again, have a prenuptial agreement, maintain separate accounts. You can put assets into a trust. Again, it's got to, maintain that separate status. And always, always, always keep really good records. You want to keep records of taxes, of increase in non-marital property, the way you use non-marital property. You always want to keep good records with that.
So Theresa mentioned a couple times about prenuptial agreements. And so to dig into that a little bit further, I think sometimes there's an immediate negative connotation around a prenuptial agreement or a reluctance of parties to consider it because they'll say, this is a long-term marriage, we're not going to get divorced. I don't want a document that talks about a divorce. But there are some estate planning implications or benefits of a prenuptial agreement. So a prenuptial agreement will typically provide or cover things other than just the division of assets in a divorce. So one thing a prenuptial agreement can do, we talked about that there can be some uncertainties, nuances about what might be separate property, what might be marital property. The prenuptial agreement can define all of that. So it can say state law doesn't apply. We agree, here's what's separate property, here's what's not separate property. As a part of the prenuptial agreement, there will be a full disclosure of financial assets by each party. And very often that's an exhibit or an attachment to the prenuptial agreement. So it'll really clarify, it'll show, who's got what assets, full disclosure. The prenuptial agreement then might say that each person's free to do whatever estate planning they want to do. So again, we're not back to those laws saying that somebody can elect to take against the will. The prenuptial agreement could say, if you wanted to, each party's free to do their estate planning, whatever they want. Sometimes the prenuptial agreement may even build in obligations, financial obligations. So let's say, for example, that one party to the marriage has much less assets, maybe he's giving up employment in connection with the marriage and is concerned about the other more moneyed spouse dying. Well, the prenuptial agreement might say if that spouse dies, there shall be set up and maintained a life insurance policy of a certain amount that's going to be payable to the surviving spouse, or in a trust for the surviving spouse as children, for the care of children. So the prenuptial agreement can provide some financial assurance for the surviving spouse. The other thing it can do from an estate planning standpoint is maybe minimize or help eliminate conflict that might be on the surface or under the surface between family members. So it could be, especially if it's a second marriage and there are adult children, maybe there's some wondering by the adult children, boy, is this new spouse going to come in and are they a gold digger? Are they going to take all of the assets? Well, the prenuptial agreement maybe helps put some of that to ease because there's full disclosure. It identifies whose assets are what, and here's what's going to happen at death. The parties are free to do this, or they'll do exactly that. So prenuptial agreements can be very beneficial as a part of estate planning when you're in a subsequent marriage. And moving on now from contemplating marriage to say, okay, marriage has occurred. Now let's talk about estate planning after marriage and with the focus on blended families. So estate planning after marriage is very much going to be impacted on the decisions or the discussions and contemplation of marriage. So if there is a prenuptial agreement, for example, as we just talked about, there might be some things that are required to be implemented or written in estate planning documents to carry out the terms of that prenuptial agreement. Or even if not a prenuptial agreement or obligations, a lot of the things that were talked about, as Theresa mentioned as well, may say that in the planning, we want to set up certain things. We're not required to by a prenuptial agreement, but we want to make sure certain things are set up for each other. Revisit those lifetime documents, the financial power of attorney, the healthcare power of attorney. Before marriage, maybe you had somebody else named as your agent, your attorney in fact, and maybe you want to update that now to have the spouse named as the number one choice. Titling of assets, again, it depends on what the couple is planning to do. But let's say, for example, if there was a house just in one party's name, and that's going to now be the residence where both live, and each person wants some assurance that upon death, that residence is going to pass to the survivor outright, no strings attached. Well, maybe you want to take that residence and now retitle it joint with rights of survivorship. Beneficiary designations after marriage, and some special implications or considerations with retirement assets, qualified plan assets. So be aware that under federal law, a surviving spouse has a right to be the beneficiary of a decedent's qualified plan. So think a 401k, for example. The surviving spouse has the right to be the beneficiary of that 401k unless they waive that right in writing. For IRAs, not the same federal right. By federal law, a spouse does not have a right to be a beneficiary of an IRA or a Roth IRA. But for IRAs, now that when a person's a spouse as a beneficiary has the ability to do some things that nobody else can do. So a surviving spouse as a beneficiary of an IRA can roll that over into their own IRA or into their own Roth IRA. And then it becomes a survivor's IRA or Roth IRA in all respects. So required minimum distributions on an IRA, not until the beginning date, which is currently 73, but it's going to raise to 75. A Roth IRA, if it's rolled over to the survivor's own IRA, no required beginning distributions out of the Roth. And only a spouse can truly roll it over. Anybody else who's a beneficiary, the IRA would actually get put in an inherited IRA without that same true rollover right. So because of this tax deferral flexibility when a spouse is the outright beneficiary of an IRA, it's not uncommon in blended families too to see the spouse named as the outright beneficiary of an IRA so they can have that flexibility. But then you have to realize and be aware that the surviving spouse, when they're the outright beneficiary of that IRA, they can do with it whatever they want. So they could pull it out, they could consume it, they could change beneficiary designations to be whatever they want. The couple may have a moral understanding that the survivor will make sure that the beneficiaries, for example, are everybody's children, but no legal obligation to do that. To create a legal obligation with those IRA dollars, the money would instead need to be paid to a trust, which certainly can be done, but now there are some different income tax considerations. So Theresa mentioned revocable living trust, and we mentioned that earlier on in the presentation as well. So a revocable living trust really in anybody's estate planning, but especially with blended families, can really be a nice tool to help protect assets. So with a revocable living trust, there's a grantor or settlor of that trust, and that grantor, that settlor is typically the initial trustee. And it's revocable. It can be amended anytime during that grantor's life. But a revocable living trust, once it's signed, it actually exists as an entity on paper. Things could be titled in that trust now if you wanted to. So, for example, a house could be titled in that trust. An after-tax brokerage account could be titled in that trust. Unlike a will, nothing can be titled in a person's will while they're alive. That will has no effect until they die. With revocable living trust, it's a living document. Once it's set up, things could be titled in that trust. And so here's a way to help give some assurance and protect assets in this example. A house is titled in the revocable living trust, an after-tax brokerage account, and the trust document says when the grantor dies, surviving spouse can live in that house for their lifetime. Interest, dividends, principal can be distributed out of that brokerage account to help pay for health, maintenance, education, support. So it's making sure the spouse is taken care of, but the spouse can't change the terms of that trust. So the trust can say now when the surviving spouse dies, here's where the assets are going to be distributed. So for example, amongst children of both parties or to only particular children. Marriage also produces a couple of different estate tax benefits, and alluded to the fact of a marital deduction earlier on that's available to a surviving spouse. So for federal estate tax purposes, there's an unlimited marital deduction for whatever passes outright to a surviving spouse or whatever passes in a proper trust form for a surviving spouse. And if it's a trust for the surviving spouse, you might call it a marital trust. But there are different types of marital trusts, and one you may hear of often is a type called a Q-tip trust. And that's kind of a funny name. You immediately think of the thing that it put in your ear. But a Q-tip trust stands for Qualified Terminable Interest Property. And that is a trust that provides that a surviving spouse will receive all the income from that trust during their lifetime. It could provide for principal to be distributed to the surviving spouse as well, but nobody else. So during the surviving spouse's lifetime, the survivor has to get all the income, could get principal, but nobody else can receive anything. And if the trust says that, and if a Q-tip election is made when the first spouse dies, so this doesn't happen automatically, there needs to be a Q-tip election made on an estate tax return when the first spouse dies. Everything that passes to that Q-tip trust then qualifies for a marital deduction. No estate tax is incurred when the first person dies. That then is included, what's in the Q-tip trust when the survivor dies is included in the survivor's taxable estate, but not subject to estate taxes as long as it's sheltered by the survivor's estate tax exemption. And things that are included in that Q-tip trust when the survivor dies get a new basis equal to the fair market value at the survivor's death. So the assets coming from the first spouse when they're deceased get a step up in basis at that point in time. If they pass to a Q-tip trust now when the survivor dies, they get another step up in basis at that point in time because they're included in the survivor's estate. So between married couple, unlimited marital deduction for federal estate tax purposes. Another benefit that's available to a spouse that isn't available to anybody else is the portability of the federal estate tax exemption. And this idea of portability has been in place in law since about 2013. And this is a potential estate tax planning benefit of being married. So the portability of the estate tax exemption means when one spouse dies, if they have not used all of their estate tax exemption, an example of not using it is just because their assets are under the level of the estate tax exemption. If all of that decedent's estate tax exemption is not used, the executor of that person's estate can make an election, a portability election, to have that unused exemption passed to the surviving spouse. So here's just an example of how that could come into play. We have Jane and Joe who just got married, and it's a second marriage for each of them, and they have adult children from a prior marriage. Jane has a $15 million net worth, a $15 million estate, and Joe has a $1 million net worth. So unfortunately, Joe dies shortly after they're married in 2023, and Joe's estate planning leaves all his assets to his children. So there's no estate tax when Joe leaves those assets to his children because he had $1 million. He left that $1 million to his children. That's well under Joe's federal estate tax exemption of almost $13 million right now. So no estate taxes when Joe dies. And before portability, Joe's unused estate tax exemption of almost $12 million would have just expired. But now after portability, if the executor of Joe's estate makes a portability election to allow Joe's unused estate tax exemption to pass to Jane, Joe's unused estate tax exemption now of almost $12 million adds on to Jane's own estate tax exemption. And so now Jane has a total estate tax exemption of almost $25 million, $25 million. So now when Jane dies, she can leave her entire estate to her children, no estate taxes at Jane's death. So even though she had a $15 million estate, which is in excess of her individual estate tax exemption, the portability election increased her total exemption, allowed her to pass assets on without any estate taxes at her death.
All right, well, Tim, thank you. You gave a lot of wonderful information. And what we want to do now is we want to, it's the end of our formal presentation, but we want to take a couple of questions. And I know there's been a couple of questions or a few questions submitted, so we'll take as many as we can. Tim, I'll pass the first one to you.
Okay. One question I saw, I haven't seen all of them yet. But one question is, can a spouse be the sole trustee of a Q-tip trust? So could the spouse be the sole trustee of that Q-tip trust? And the answer is yes. So if that Q-tip trust is drafted correctly, the spouse can be the sole trustee. So the spouse has control, still has a fiduciary duty to remaining beneficiaries, remainder beneficiaries, but could be the sole trustee. Now, oftentimes I'll see those Q-tip trusts drafted just because the couple want to have it a little bit different. They might say the surviving spouse and an adult child of the decedent are co-trustees, but the survivor could be the sole trustee.
Another question. Oh, I'm
go ahead.
sorry.
Well,
Say another question we had submitted was, is Iowa a community property state? And it is not a community property state.
It is not a community property state. That's correct.
Tim, I'll let you do one more and then we're going to have to wrap it up.
Okay. Another question was, does the portability of the estate tax exemption expire in 2026 when the estate tax exemption is scheduled to drop? And the answer is that portability is not scheduled to expire. Portability is scheduled to remain in the law. So portability came in around 2013. That would have been under the Obama administration. And it appears that on both sides of the aisle, they like that idea of portability. The parties may disagree on what the level of the exemption should be, but it appears that parties like portability. I don't see that changing, but never say never.
All right, thanks, Tim. We have a lot more questions that were submitted. So what we'd like to do is, if you have a question, it's also kind of hard. This is a pretty personal topic. So if you have a specific question, or if your question didn't get answered today, please put that on the bottom of the survey form and we will make sure we answer that. Also, when we look at this, our team would really just love to connect with you and talk about your unique situation. Like I said, it can be kind of uncomfortable to talk about it on a webinar. So we want to talk to you about your unique situation. And if you'd like, we would certainly want you to talk with one of our team members for a 15-minute consultation. And this way we can answer your specific questions. We certainly want to thank you for taking time with us today. And as a reminder, we're going to have a survey pop up in your web browser after the webinar ends. And again, if you have any specific questions, please either put them in your in the survey or go ahead and contact us, and we would be very, very happy to help. We certainly appreciate your attendance today. And if you want any information about Savant and the services we offer, again, we'd love to discuss those with you.
Thank you, everyone.